Are you considering filing a Chapter 13 bankruptcy reorganization without a bankruptcy attorney? Read some books and think you can do this? Some paralegals say they can do the papers and save you thousands of dollars. Sounds great, doesn't it? Unfortunately, the failure rate for people filing a Chapter 13 reorganization without an attorney is 99.99%. That includes people who use so-called paralegals that do not know the law and cannot advise you as to how to do even a regular Chapter 7 bankruptcy case right. Hello, I'm Gary Fraley. I'm a California bankruptcy law specialist in Sacramento, California. I represent people and businesses in most of Northern and Central California, the Bay Area, the Gold Country, and the Eastern Sierras. Yes, that number is accurate. If anything, it understates the failure rate. You are much more likely to be in an accident today than you are of ever having a successful Chapter 13 plan without the benefit of a highly skilled attorney. Now, if you doubt me, would you believe a Chapter 13 bankruptcy trustee? How about Chapter 13 trustees from all over the United States? The National Association of Chapter 13's trustees has its own website called consider13.org. Here's how they put it in the caption of their article on this issue. The new math, your Chapter 13 case plus no lawyer =0 success rate. I have the link to their website below this video so you can see for yourself that it's true. Think about it. If you needed brain surgery, would you consider doing the brain surgery on yourself? How about having the veterinarian's assistant do brain surgery on you because they can read a book on the subject and charge you less money than the brain surgeon? Would you do that? The same is true about financial brain surgery. There are numerous reasons for this terrible Chapter 13 plan failure rate. First, there's something called the Chapter 13 means test. You have to know how to do the means test, which is difficult to get the correct information calculations right, that you are guaranteed to fail. I've seen hundreds of means tests done by people who are not represented by an attorney. I've yet to see a single case where the means test was done directly and correctly. Unfortunately, many attorneys don't get it right either. A few bankruptcy attorneys can get it right. However, your odds vastly improve as they're likely to spot and avoid most problems. This is why finding a skilled bankruptcy attorney is an absolute must. Now, the means test looks at household size and household income. In most cases, everything depends on understanding the definitions of words like household and income. It sounds simple, but it isn't. Judges all over the country disagree as to what these terms mean. Forget the dictionary. These have precise meanings based on court cases determining what Congress supposedly meant when they passed these bankruptcy laws. All this is only the first step of the means test. It gets much more complex if you have to go to the second part of the means test, where some information is based on past actions like charitable contributions, some actual expenses, on some that you will have or should have as future expenses. Many of those expenses that they calculate for you have nothing to do with reality. They are based on IRS estimations of what they think you ought to live on. And we all know how generous they are. When it comes to bankruptcy income and expenses, you get to the next issue. What is your actual income? What are your actual expenses? That information will show on the I&J, or income and expense schedules. It's where you find out what you have left at the end of each month without considering payments to unsecured creditors and secured debts that you're going to pay through a Chapter 13 plan. What you think is a necessity, like having kids go to an expensive private school, as an example, is a luxury if you can't afford to pay your creditors in full through the plan. If your net income is more than the means test says you have available, you get to pay the higher amount. Non-exempt assets. The third issue is what you have in things that would have to be turned over to a Chapter 7 bankruptcy trustee had you done a Chapter 7 bankruptcy. These are called non-exempt assets. Whatever the value of those assets exceed priority debts, like taxes, must be paid to the unsecured creditors in a Chapter 13 plan. This is called a liquidation analysis. Now, priority debts, you have to determine how much must be paid into the bankruptcy plan to comply with the bankruptcy code. The biggest example would be paying all back priority debts like taxes. That can also include back support obligations. Now, student loans, which often cannot be wiped out or discharged in bankruptcy, are not priority debts and can get the same percentage as general unsecured debts like credit cards. And to the extent that you have a plan that only has to pay 30 cents on the dollar to the credit cards, the student loan lender is going to get 30 cents on the dollar there. The problem is when you're done, unlike the credit cards that go away, the other 70 cents on the dollar that didn't pay, you still owe, plus interest and so forth. Very nasty little alligator there. Now, secured debts. You must pay most secured debts in the reorganization plan unless the payments on the contract are longer than the plan can go. This usually includes vehicles, furniture, and other personal items that you want to keep. Perhaps jewelry on payments, or the stove. Now, stopping foreclosure in Chapter 13 reorganization. So if you have a home in foreclosure you're trying to keep, what you're behind is called arrears and must be paid to bring the mortgage payment current through the Chapter 13 reorganization plan. You'll pay 1/60th of what you're behind to bring that mortgage current over the next 5 years. A recent court decision now holds that you must also pay interest at the interest rate that your mortgage is on that arrears over the next 5 years. Most bankruptcy districts also require that you pay the ongoing mortgage payment through the Chapter 13 plan. Now, what hurts about that is you're also paying a trustee to handle that payment. Now, Chapter 13, I keep hearing this all the time over the years, it does not allow you to modify the first mortgage. However, in some situations, you may be able to remove or lien strip a second mortgage and still keep your house. This only works if the first mortgage debt is more than the value of the home. Nowadays, that is rarely the case. These are all very complex and technical. Some filing without a skilled bankruptcy just have no chance of success. Now, like I said, Chapter 13 trustee gets paid 1/10 of the money they handle on top of what you're paying the creditors. Now, Chapter 13 is not available to everybody. First, if it doesn't breathe, it can't qualify. Corporations, partnerships, limited liability companies cannot file Chapter 13 reorganizations. Individuals and married couples can qualify and file Chapter 13. But there are fixed limits on the amount of debt you can have and still qualify to do a Chapter 13 bankruptcy. Right now, the secured debt limit is $1,257,850. Unsecured debt has a limit of $419,275. This again might sound simple, but you have to understand definitions are not always what they appear to be. For example, if you have a mortgage and that mortgage is more than the value of your home, or if you have a car and the debt on the car is more than it is worth, the difference between the value of the house or the value of the car and the amount of the debt, that difference for this purpose is treated as if it were unsecured debt. Now that doesn't take that lien off of the car or the house, but you can find that you have too much debt to qualify to use a reorganization, even though all of the debt is secured with a mortgage or car loan. Now what happens if you have a Chapter 13 bankruptcy and it's dismissed? If you file a Chapter 13 and it is dismissed for any reason, you will lose the restraining order called the automatic stay. That is what keeps people from foreclosing, from repossessing vehicles, garnishing you, levying on your bank accounts, any of that action to try to take something from you or sue you. Once that is dismissed, the creditors can proceed against you as if no bankruptcy case had been filed. So they can complete their foreclosure. They can levy on the bank account. They can garnish the paycheck, repossess your vehicle without notifying you in advance. If you do brain surgery on yourself, we live with the consequences. What could you lose if your Chapter 13 bankruptcy case fails? Do you want to risk the financial disaster that would happen if you don't do it right the very first time? What I've discussed with you here is just the tip of the iceberg of bankruptcy issues. It wasn't what was above the waterline that sank the Titanic. It was what it was below and unseen. Do yourself a huge favor. Do not do this on your own. Find a skilled bankruptcy attorney and do this right. Most attorneys will give you a free initial consultation. Now, if you like an in-person or Zoom strategy session with a California bankruptcy law specialist worth $450 at no charge to you, and you're in a county that we serve, give us a call at 916-485-5444 or fill out the consultation form in the upper right-hand corner of our SacramentoBankruptcyAttorneys.com homepage. The link is in the description below this video. You can also see what counties we serve by going to the SacramentoBankruptcyAttorneys.com/counties link. It is also in the description below. You can also get a free copy of my book, 49 Do's and Don'ts You Need to Know When Considering Bankruptcy. It is both informative and written for real people. It also has a bit of my quirky humor in it. The link is also in the description below. If you found this information helpful, please give it a thumbs up, comment, and subscribe to my YouTube channel. Don't forget to hit the notification bell to be informed when I upload my next video. There's a saying, knowledge is power. Isn't it time you got your power back? This is Gary Fraley signing off for now. I look forward to you joining me again for my next video.